In the final collapse of states, governments, it's corruption that does it, usually driven by money or by the desire to gain more political power. And the more political power you get, of course, the more money you get. It's always corrupted that way. And that's what we're seeing.
One-ounce silver 2022 Noah's Ark coins at $4.25 over spot. Quarter-ounce silver 2022 Noah's Ark coins $3.25 each over melt. Call 1-888-81-LIBERTY. 1-888-815-4237.
Welcome back to Liberty and Finance. We're always privileged and honored to have this returning guest. Dr. Edwin Vieira is a doctor of jurisprudence and a PhD. He's a constitutional attorney who has argued cases up to and including the U.S. Supreme Court. He's written the book Pieces of Eight about the roots of sound money, silver specifically, in our countries and the world's financial systems. He's here with us again to talk about the grave specter of overreach and trespassing of private property rights exhibited most recently in the raid of Trump's personal home at Mar-a-Lago, Florida, but also what that might imply about our own vulnerability going forward to government seizure and intrusion into our private property and our private affairs. Dr. Vieira, thank you for joining us again here on Liberty and Finance.
Oh, it's my pleasure to be with you.
You cast a long shadow from your decades of experience, both from your analysis, your research, your writing, and your litigation and defending of cases. We wanted to get your input right now just because of the recent event that kind of sparked people's renewed concern. Certainly there's been enough things that have happened over the past 2 years that were breaking with convention and throwing constitutional protections out the window, actually longer than 2 years. I guess go back to the Patriot Act and beyond. But anyway, especially accelerating recently, where it seems more often than not now we're seeing just either blatant disregard for or dereliction of duty or things being done under the color of law but not honoring any of our constitutional rights, and that we'd like to get your specific feedback on two things in particular. One is the raid by the FBI on Trump's Mar-a-Lago estate, what we know about that and what it indicates to you as far as the danger that's posed to ordinary law-abiding citizens by these three-letter agencies that seem to be, in many ways, marching to their own drummer, and what can be done about that. Number two is for people who have been sound money advocates either a long time or more recently and are storing metals either at home or in vaults such as Brinks or other major vaulting institutions. They have renewed reason for concern, and a lot of questions are arising about what do we have any historical precedent, or do we have any reason to believe that there's increased risk of the potential of government intrusion and seizure into private property, including vaulted precious metals, gold or silver. So can we first start with the Trump Mar-a-Lago raid and your view of what it's revealing about the behavior of these three-letter agencies and what can be done about it?
Well, the first thing that comes to the fore, and this is mentioned all the time in the media, is the unprecedented nature of the event. That being Trump, as a former president of the United States, they serve a search warrant instead of a subpoena on him at his own home, and then basically rummage through the entire property on the basis of a search warrant that, to use the old-fashioned terminology, is a general search. That is, the language was so sweeping that it gave the FBI agents the opportunity, at least on the face of this search warrant, to rummage through any kind of paperwork or actually other things that they wanted to look into, going all the way back to the beginning of Trump's term in office. It's a little hard to believe that that would have been justified by any statement of probable cause, because they were talking about particular documents that he supposedly, I don't know which documents he did or didn't take from the White House when he left. And the Fourth Amendment is very clear. In fact, I just pulled it up now so I can read the exact language. You have to have probable cause, which is supported by an oath or an affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this search warrant specified the place, the Mar-a-Lago residence, but it was extremely broad with respect to the things to be seized, these various documents. And we know that it was interpreted in an extremely broad fashion by the agents because they took all sorts of things that had no relationship whatsoever to what we've now found are the various statutes that they claim might be violated. I mean, they took the Trump's passports and some letter that he had received, various letters he received, completely irrelevant to the claims made in terms of the possible violations. So that's number one. They were running this thing as what used to be called a general warrant. That's what the colonists complained of with respect to the British. They get a warrant, and the warrant would say, well, just go search this place. Anything you find, bring it back. All right? And that's, of course, another problem with something that looks like a general warrant. Once they get into a property and the agent sees something in plain sight, right, as a crack cocaine or whatever, is there something illegal that they see in plain sight, well, now they can seize that precisely because it is in plain sight. But the question becomes, what right do they have to be in that property to begin with? So there's a lot of debate about that question, whether there was probable cause with respect to particular items, particular things, as the Constitution says, and the agents went beyond that because they had generated basically a general warrant, which this magistrate judge accepted. And I don't think he ought to have accepted that. It's another question, whether seeing that kind of language, he should have said, well, I'm not going to give you this, or I'm going to strike that out. You're going to have to be more specific in what you want. And so there's one danger. That's the way he seemed to be willing to operate, to go back to the whole British principle that the colonists found obnoxious in using general warrants whereby they can make sweeping claims of probable cause and then go in and, well, we find whatever we find, and then we go from there, right? We'll generate a crime based on some evidence that we've obtained without probable cause to begin with. The difficulty with these search warrant situations is, well, is it really going to be correctable by the judiciary at this stage? And we've seen the affidavit that supposedly provided the probable cause justification, and I don't know, it was out of 30 pages, 20 of them were blacked out. So for various claims that they made, apparently the magistrate judge accepted this, blacking out this redaction. So we don't know. That type of information hardly ever comes up in normal procedure until after grand jury has come down with an indictment. And so sometimes that material in the affidavit will be made available to the defendant, and then the defendant somehow could challenge the validity of the search. And if the search is invalid and the evidence would have to be stricken, then he could challenge the validity of the indictment, or perhaps he could bring it up in the course of the trial when that evidence is attempted to be introduced by the prosecution. It all becomes problematic with respect to where in this procedural morass what's under the blacking out in the affidavit is going to come to the fore and perhaps be used by the Trump defense team, at least, to challenge the search itself or to challenge various elements of the, quote, items that the FBI took and then would use, the prosecutors would then use in front of a grand jury or in front of a trial court. So I think it's highly problematic in any event, this business. And you have the lawyers arguing back and forth on the basis of what's come out so far. Oh, the search was valid, or the search wasn't valid to one degree or another. And I don't think that's going to be resolved. What it does tend to show, and I think this is true not only at the level of the FBI, but going down at the state level, is basically a disregard for the niceties of the Fourth Amendment. requirements of specificity, opening up the ability of these so-called law enforcement agencies simply to go into private property and essentially search for whatever they might find on the basis of some kind of sweeping statements made before a judge. And the judge tends to get, these judges, I don't know whether you can quote-unquote fault them in practice. They look at these things and they treat them on the basis primarily, well, there's some expert here in the law enforcement area in the basis of informers or whatever they have, and I, as a judge, am not in a position to question that, and the man is swearing under oath that this is the information he's received, this is the information they've developed, and how am I going to challenge that? Now, if I were the judge, I would be perfectly willing to challenge a lot of these things, especially to bring some of the affiants in, the people who have sworn under oath, in front of me and start asking them some questions, especially in a case like this, because we go back all the way to the pre-election of Trump. Right? We go back all the way to 2015, when this operation against him started, involving the FBI, and a great deal of what went on turned out to be a hoax. Whether it was perpetrated on the FBI initially and then the FBI ran with it, or whether the FBI was one of the perpetrators. But that was all exposed, right? And then we had the 15 intelligence agents, or honchos, whatever, the leading intelligence figures that told us that the Hunter Biden laptop was Russian disinformation, more tying this into the Russian collusion, Russian involvement scenario that they've been trying to build around Trump. So the whole thing is very suspicious from what I would say from a procedural point of view, and also whether there are people in the FBI who are continuing this Trump harassment operation, and that this is part of it. Then you also get into the extreme complexity of this particular case because of the legalities. There's the Presidential Records Act, and that really is what should control the situation. But the Presidential Records Act does not have a criminal violation penalty involved in it. I think for the obvious reason that when someone wrote that, it would be very problematical to bring a criminal charge against the president who had already seen all these documents and was in a position to classify or declassify whatever, because the peculiarity of the president's authority here. But what the government is trying to do is say, well, there might be a violation of the Records Act, and on the basis of that violation of the Records Act, we can call in other statutes, the Espionage Act from 1917, obstruction of justice, whatever. We can use some other criminal hooks tied onto a violation of the Presidential Records Act. And that's something that's also new. That has been done the last few, well, it goes back more than a few years, maybe it goes back 8 or 10 years, cases I've seen, where, especially in the Enron case, the securities fraud, huge securities fraud case, where they were trying to do the same thing. They were trying to invent, and I think they're actually successful there in 1 or 2 cases, invent a criminal charge that really wasn't spelled out in the controlling statute. So that's another thing. This is not simply the old Stalinist idea of show me the man and I'll show you the crime. It's show me the man and I'll invent a crime for him. I'll take his circumstances, I'll create some kind of a crime for him where it isn't clear that there was a crime before. That's extremely dangerous because obviously that's completely open-ended. Right? There's no way you get around that. You might be able to attack a search warrant because the affidavit does not specify particular things and they extended the search beyond what was under that blackened out part of the affidavit. But when they can simply create crime, you put 2 or 3 statutes together, A plus B, and then you say, well, this results in crime C, which is not spelled out in either A or B. Now the area for inventiveness becomes infinite. And especially the area simply of targeting people, whether or not they convict them. You have to remember, in one of these criminal cases, defendant could be spending hundreds of thousands of dollars or more for defense lawyers. Oh, he's acquitted. So what? He's bankrupted. His reputation is torn to shreds. Right? I think of the example of Trump in the New York case that he's involved in, one of his business-related cases, where he asserted the Fifth Amendment X number of times. I can't remember how many in that case. And what was the attitude in a lot of the media? Well, he wouldn't be asserting the Fifth Amendment unless he was guilty, right? Well, that's not true. There's a famous Supreme Court, maybe not famous to these people in the media, called Slochower versus Board of Education of the City of New York, in which Slochower asserted the Fifth Amendment. I think this is one of these cases that involved people who were unfit for certain offices or whatever the language was because of involvement with Communist Party connections or communist organizations or whatever. And when they asked him those kinds of questions, he took the Fifth Amendment. The Supreme Court said, well, you have to understand that people take the Fifth Amendment so that they won't become embroiled in ambiguous circumstances. You may not necessarily actually be incriminating yourself in the sense that you know you've committed a crime, but you don't want to become involved in admitting to something which is sufficiently ambiguous so that someone is going to charge you with a crime, even though you personally know that you're not guilty. And they pointed that out. And you look at especially these kinds of prosecutions that deal with business crimes, right? Securities fraud, which is a very vague area and so forth, of that nature. And personally, that's what I would have told any client like that as an attorney. I say, oh, they're looking, especially if you have the impression that they're looking to go after my client. They're really trying to pin something on my client, perhaps for political reasons. I would tell my client, everything but your name and address, you take the Fifth Amendment. Because someone will take your answer at some point and try to twist it into some sort of admission or implication of awareness of criminal behavior or criminal intent. So just take the Fifth Amendment and everything, let them figure out what it is. It's complicated enough so that you could potentially incriminate yourself inadvertently by giving a somewhat confused answer to a trick question. Just no, absolutely not. So, but anyway, that's the attitude. So now they've put Trump in this position as well. Oh, he's taken a classified document, nuclear secrets, all this speculation, and he's taking the Fifth Amendment there in New York. He must be as guilty as sin across the board. And what is this aimed at? Well, maybe it's aimed at preventing the Republican Party from nominating him for the presidential election in 2024. Right? Because we don't want to take a chance. We elect the man, then he ends up being prosecuted, or he ends up being prosecuted during the electoral period. This fouls up everything in the election. The Democrats win. Let's go with somebody else. Let's go with DeSantis or whoever else has a clean record. And it could be just simply tarring the Republican Party. Right? Trump is the leader of the Republican Party, the MAGA, M-A-G-A, the MAGA group, and look, he's a criminal. He was taking defense secrets off with him and so whatever. All right. Now, the thing just go back one step, I would ask who advised him to take all those documents out of the White House? What legal team would sit down with him and say, oh, there's no problem here? They've been going after him in the FBI for the 4 years of his presidency, and then afterwards vilifying him for the next 2 years. And they're going after him with respect to any documents National Archives is. Why would he have taken it? And the story, that's what's fascinating about this. The story that now comes out is he needed to take these out because they showed some of the things that had happened with him or with Hillary Clinton or whatever, and he didn't want that to be destroyed. Right? He didn't want those records to disappear. And I think a lawyer would have told him, well, he was still president. Well, Mr. President, we'll just be sure that we declassify all these records with whatever forms and so forth need to be filled out, and then you publicize them. And once they've been publicized, now everyone in the whole world would have access to them. There's no way they're going to be destroyed. And if it turns out later on that they are destroyed in the National Archives, well, that's another example of some kind of nefarious business that's going on behind the scenes. But don't just take them out without, in a sense, making that clear. That's why you're doing it. Publicize them. If they're declassified, and while he's president, he could certainly have followed. So he didn't do that. So there's a whole mess here that involves not only potential wrongdoing and actually kind of stupid things being done by the Department of Justice, given the person they're going after. You think they would have been a little more, they would have towed the line a little more closely to the language of the Fourth Amendment so that they could clearly have justified what they're doing. But there is apparently a lot of kind of loose thinking on the part of Trump and his various advisors. But what it does show is that obviously, if the FBI wants, or any law enforcement agency really, but the FBI really wants to go after somebody, and a search is part of that process to develop some evidentiary basis to go in front of a grand jury, they will go well beyond the Fourth Amendment. And they will hope that they can get it in front of a judge. There's their search warrant affidavit. They can get it in front of a judge who will more or less rubber stamp it, because to a large extent, judges really do just rubber stamp these things. And then, all bets are off, because once they're in the property, anything they see, they can take. And in fact, once the cat is out of the bag, what happens? They take a lot of documents back which they shouldn't have had access to, because they couldn't have written an affidavit that would justify a search to seize those documents or those things, cell phones or whatever that might have evidence on them. They take that back, and people at the FBI now have access and look at those things. Well, you can't erase what's in someone's mind, right? The judge may say, well, you should never have these documents, you have to return them, but you can't erase what's in their minds. And then they can use that knowledge to perhaps find other leads to develop other kinds of, evidentiary structures to support some criminal charge. And it's very difficult after the fact to say, well, the only reason they found this other evidence 2 weeks later was because they had looked at this material that they shouldn't have had 2 weeks earlier. And the FBI agent says, oh, no, I don't. It had nothing to do with that. I wasn't thinking anything about it. I had this separate lead coming from Joe Schmo over here, right? And
that's not even to mention the potential for leaks of that information out to the press or to the public.
Oh, well, that's another thing. That's another thing, to use information that would not necessarily be useful in a criminal context, but would be useful in tarring the subject. You put it into the hands of the talking heads in the anti-Trump media, and they can say this, that, and the other thing about him. It might not be useful for a grand jury, but it will be certainly useful for political purposes. And the FBI, leaking, this goes all the way back to Hoover, right? Hoover was a master of this. Various kinds of blackmail that he used, and leaks were one of them. Or the Times Apocrypha, maybe Apocrypha would hear this story, that he came to John Kennedy when Kennedy was president and mentioned to him that they had information about Kennedy's trysts with various women, some of whom might have been foreign agents, one in particular from East Germany. And Hoover was saying, oh, well, we found these out from some kind of other activities that we were doing. We kind of stumbled across this, and we just want you to know, Mr. President, that woman may be a dangerous foreign national security problem. And of course, what did that do to Kennedy? He didn't realize, well, wait a minute. Hoover is not telling me this to put me on my guard about national security. He's telling me this so that I will know that he has information about this other kinds of activity in which I'm involved, which could hurt me very much politically. All right? So don't mess with Hoover, because there will be leaks to whatever these various newsmen that Hoover had close relationships with. So that's another problem. And I think this has just gone on for a long time, but it now surfaced like Mount St. Helens when they pulled it on Trump. And I think they pulled it on Trump because they've been pulling a lot of things on Trump since he ran for office, for heaven's sakes. And now especially, and you can think of a lot of different strategies. They don't want him to run. They want to tar the Republican Party. They want to pressure the Republican Party into going after someone else. Maybe they want to pressure the Republican Party into having a nomination fight at the Republican convention, whatever it might be. Right? Because many times these are multi-pronged strategies. But I don't think that the search warrant approach was something that was necessary. This was the thing they had to do. It was absolutely necessary, because if they hadn't done this on that day, Trump would have had a dumpster fire destroying all the evidence. Usually that's the reason for a search warrant like that, right? Someone's going to flush the narcotics down the toilet. Someone's going to burn the incriminating business records, right, that show the stock fraud or whatever it is. And so they come to the judge and say, we need this. We need to essentially break into that house, because if we don't, the evidence is going to disappear, or in some other way it's going to be spoliated. damaged, and then we won't have the ability to use what we're entitled to use in front of the grand jury. And that wasn't the case. I mean, they admitted that right away. They came to the judge and, oh, yeah, we have all this stuff. It took them a long time even to get the affidavit together and the search warrant together because they had earlier discussions with Trump's lawyers, lawyer-to-lawyer discussions about this. So it takes them a long time to figure out, oh, well, we finally need to do a search warrant. And then the search warrant comes, on Friday, and they didn't do the search until the next week. They gave them 3 or 4 more days to supposedly destroy the evidence. So I look at the whole thing and I say, okay, this is theater. It's political theater because it was Trump. But underlying that has been the steady deterioration for a long time, because a lot of these problems with the Fourth Amendment come up with the Supreme Court finding amazing exceptions to the Fourth Amendment. It's amazing how they really gutted the Fourth Amendment at the Supreme Court level. So you have the judiciary participating in this, and then even what's left of the limitations, as in this case, where I think a judge should have, I would have said, if I had been reading it, wait a minute, this is far too broad. I'm not going to allow this, and I'm not going to just scratch out a few things here. You take it back to the drawing board. I'm not going to say, I see what you people are doing, I'm not going to let you do it. That's it. Take it back, fix it. Okay, but no, the judge signed onto it. And then there's a peculiarity of this judge recusing himself in an earlier case involving Trump, and shouldn't he recused himself here? Okay. And all I say in the long run, I don't think that will have any effect until it gets to the point at which somebody tries to introduce evidence that was carted out in those boxes, and not even at the grand jury, but at a trial after Trump is indicted. Because you know what happens to the grand jury? The prosecutors bring in the witnesses they want. Now, you can ask to testify, which then puts you in trouble because you'd have to assert the Fifth Amendment under some circumstances in front of the grand jury. And what does that tell the grand jury? Well, you must be guilty. We're going to indict you. But the prosecutors present what evidence they want to the grand jury. Grand jury has no ability, in practical terms, it does legally, but they never do it, to investigate themselves, to demand that the prosecutors bring other witnesses or other documents for them to look at. And then they sign off on it. Right? We found probable cause, we indict this man, and it goes to trial. And there are the famous statement, I can't remember which prosecutor in New York said this. He said, under today's procedure, a competent prosecutor can get a grand jury to indict a ham sandwich. Right? The grand jury is basically a rubber stamp. And it's like a pettit jury. I mean, they keep off the people that they think might be too independently minded. I mean, I was called to one grand jury once. I'm a lawyer. Of course, you're not going to listen to me. You're not on it. I'm not on it. We don't want someone there that understands what's going on here and might ask some questions in the grand jury room and maybe get the other grand jurors thinking about it. So they've taken those procedures, which was supposed to be the ability for the public, as it were, the people, to stand between the defendant and the prosecutors or the government. So we had another layer of check and balance in the system at the grand jury level and then at the trial level. Grand jury is supposed to be made up of people who are sensible, and they're going to be looking at this and saying, well, wait a minute, the government's going too far. And the same thing when it gets into the trial. And what we see at the grand jury level, the grand jury is pretty much a dummy operation. They're dependent upon, those jurors are dependent upon the prosecutors, and the prosecutors, let's be blunt, are really never fair. They're trying to make a case, right? This is a debate. In any kind of debate situation, each debater is making his own case. He's not making the other party's case. And in the grand jury case, one of the debaters isn't there. The defendant's people are not there. When it gets to the trial, of course, then, there is that adversary relationship. But the reality there, too, is that, a lot of the evidence is highly ambiguous. Maybe they shouldn't have been there in the first place, et cetera. I look at most of these complicated trials, and I say they are, that the lawyers have spent more time with method acting than they have with law. And in fact, they have continuing legal education goes on in this state as well as others. Lawyers have to spend, in this state, 12 hours taking various courses in order to satisfy that. And one of the courses that comes up every year, you're available, it's available, is trial tactics. And really, I went to one of those at one time several years ago, and I said, well, this is a course in method acting. This isn't even a course in logic, right? Or legal, what should I say, rules of evidence or whatever. It's like how you cross-examine a witness. And one of the tactics was, well, you ask him questions 3 different ways, right, to try and trip him up or to try and get a contradiction, right? And I thought to myself, well, what the heck is this? What does this have to do with the reality of the situation? It's hardly scientific in the sense that it's verifiable or falsifiable or repeatable. It's kind of like a one-act play performed once in front of one audience and one set of critics, and you never see it again. And it depends upon the skill of the actors. And it depends to a large extent on the bias of the judge, and then, of course, on the ability of the jurors to, what shall I say, to disassemble false arguments that are presented by either side. So I think Trump has a lot of problems because I don't think anything is going to come out of this search warrant business. I don't think they're going to suppress, get specifically into what was taken out of there that the FBI doesn't admit it shouldn't have taken and the FBI returns. They're not going to be able to stop that probably, almost surely, at the grand jury level. The only place where this evidence can be attacked is in the trial. What they're hoping, I'm sure, is they can get that affidavit opened up. And then they can say, oh, this thing was so broad that they shouldn't have been allowed to take anything, or there are specific items that they did take, and they'll have to have an inventory of those, won't they? There's specific items that they did take that they shouldn't have taken under the language of this affidavit that was valid. And so we can keep that out. Keep that out of what? Well, I guess I keep it out in front of the grand jury, but not keep it out of the minds of the investigators. They've already seen it, right? They've made copious notes, I'm sure. So, they can argue, as people back and forth can argue as much as they want about the Trump situation in the media. But the real problem goes way back. It goes back to the desire of the investigatory agencies, state and federal, or federal and state, to get as much material as they want with the least amount of actual prior investigation. Right? They want to be able to make sweeping statements, say, oh, we got probable causes, and whatever it is, and the judge will rubber stamp it, and then we'll be able to go and sweep up with our vacuum cleaner, whatever, and let the defense figure out how to keep it out of the trial, how to keep it away from the jury at the trial. And unfortunately, the judges, going all the way up to the Supreme Court, have been willing over the decades now, we're going back into the last century, to expand the list of Fourth Amendment exceptions, or to use what I call elastic language in describing what would constitute probable cause, what would constitute in plain sight, so that you could pick up something that wasn't part of the warrant, but you supposedly saw it, right? So this is kind of the amazing thing. They got this warrant, which they claim allowed them to go into Melania Trump's closet. Once they were expecting what documents are hidden in there, and once they opened that up, we found this. We found a crack pipe or something, whatever it would be. Not suggesting that was there, but they find something that's obviously an illegal item, not covered by the search warrant, but it was in plain sight. After we pulled all the clothes out of her wardrobe. So it's that type of situation, and that gets you back to the accountability, responsibility question at the highest level. When these agencies, especially the investigatory agencies, are doing this, who's going to hold them accountable? Well, it's supposed to be the courts, because they have to come to some judge or magistrate to have approval for a search of this nature. One would think it would also be within the Department of Justice itself, because people are screaming that, well, they have protocols and they shouldn't, internal protocols. But they don't have to follow those protocols in the sense that the search warrant is invalid if they don't do it. That's just a kind of an internal rule that they have. So it's the judge that's supposed to stop this. Well, in this case, he didn't. Well, now what? Well, the grand jury won't stop it because the grand jury is going to be shown only what the prosecutor wants the prosecutor to see, right? So it would be coming in front of another judge if things that shouldn't have been seized were seized, and then will be used in a trial in front of a jury, a regular criminal trial. Will that judge rule that these particular items, documents, whatever they are, should not have been taken in the first place, and then cannot be used? And secondarily, that some of the documents that were taken originally, which shouldn't have been taken, have led the prosecutors to other evidence, and that other evidence called the fruit of the poisonous tree. That's it, kind of the joke terminology the lawyers use. That is, that other evidence that they get, they wouldn't have gotten if they had not looked at the evidence which they improperly seized in the first place. And so that's an argument that can also be made, but you have to prove that connection. So you look at all of those levels and you say, well, my God, the defendant is put in this very difficult position of having to climb that ladder, argumentative ladder, all the way up to the trial. And he's probably only in that criminal trial because he didn't have an opportunity to argue at the earlier, lower rungs of the ladder, getting up to the indictment. Right? So it has to be stopped at the level of the law enforcement agency itself. And the only way that's done is, well, if you go out and produce a fraudulent affidavit, get a fraudulent search warrant, and so forth, especially for political means, for any reason, then you, the individuals assigned on to those things within the law enforcement agency, are going to be held accountable in some serious way. And the first step of that would be the initial judge. But he's reading the search warrant, he's reading the affidavit, and he should be saying, well, I'm not so sure about this. Go back and correct this language, give me some more specific language, or you have an affiant that's talking about an informant, bring the informant in here. I want to question him. Oh, well, you don't want to release his identity. Put a hood over his head and bring him in here and I'll question him. So that in cases of, especially the high-level political type cases, you're going to have a real searching, if I can use that word, searching inquiry into the basis of the search warrant. And then if you find something wrong, then that affidavit was written by an individual, false documentation or whatever, then you've got to come down on those people with specific penalties. It's not just that they don't get the search warrant approved. It's something happens to them. And, of course, we don't have that. And we have no one talking about that. And there's the grave difficulty. And as soon as someone starts talking about, well, I shouldn't say maybe disbanding the FBI, but taking serious remedial steps, then the attack comes, you're attacking the FBI. This is an organization which is incorruptible and essentially infallible, and on we go. I mean, that was the Attorney General's position, Merrick Garland's position. How can you dare attack the FBI? Well, you can dare attack the FBI the same way you can attack the Uvalde Police Department. Right? That was more obvious because children and teachers were killed because of the incompetence and stupidity of those people. But if you can attack the Uvalde Police Department, why can't you attack individuals in the FBI who also are engaged in incompetent or improper behavior? In fact, one would think that would be something that the Attorney General, head of the Department of Justice, would be very concerned about, make sure that we don't have this. And yet it's exactly the opposite. It's all politics. This is the problem. In the final collapse of states, governments, it's corruption that does it, usually driven by money or by the desire to gain more political power. And the more political power you get, of course, the more money you get. It's always corrupted that way. And that's what we're seeing. And then the system, the check and balance system, fails because at one or more links, the shears of corruption, if you will, have cut the link and prevented the link from functioning, taken it out of the loop, as it were. And that's why I always come back, and we're not going to discuss that today, but I always come back to, and maybe we should. If you look at the President of the United States, let's take Trump as just an example. Constitution provides, Article 2, Section 3, the President shall take care that the laws be faithfully executed. Now, you think about what that might include. If you had no agencies having been set up. This is the first day Washington comes in, he's sworn in. What could he do to take care of the laws be faithfully executed? Well, he could become the investigator. He could become the prosecutor in front of the grand jury. He could become the prosecutor in front of the trial jury. And when the defendant is convicted, Washington could also become the warden of the prison to which he was sent to serve, a sentence. The president could do all of those things. And that's a constitutional duty he has. It's a constitutional right. It's constitutional power. It's a constitutional immunity. He can't be stopped from doing it because it's a constitutional authority he has, which means that the Congress cannot pass a statute saying, oh, well, we're going to create an investigative agency called the Federal Bureau of Investigation, and it will do these things, and you, Mr. President, can have nothing to do with that. That right there is unconstitutional. That he can have nothing to do with it. That it's an independent agency performing his functions and preventing him from performing his functions personally. Now we had the interesting situation with Trump, that Trump was looking at this Russian collusion claim, and he personally knew that it was false because it was claiming he had done this, that, and the other things. So he personally knew this was false. Right? So he knew that some kind of improper behavior was going on within the FBI. Maybe it was a criminal conspiracy. Maybe it was simply incompetence and stupidity, political bias, whatever it was. But they were running an operation on him, an improper operation on him within the FBI. Did he have the constitutional right to take care of the law, take care of the laws be faithfully executed by going into the FBI, finding people who were not part of that corrupt operation and saying, you and I are going to investigate this? Think of the paradox. The agency that's supposed to be aiding the president in faithfully executing the laws created by Congress for that purpose is engaged in some kind of rogue operation to destroy the president personally and destroy the presidency. That is the person's inability to function as president. And the president, who is constitutionally given the authority faithfully to execute the laws, can do nothing about it? I mean, on the face of it, it's an absurdity. And that was the situation that Trump found himself in. And people were telling him, including his own two attorney generals that he set up, right? Sessions and then Barr. Oh, well, there's nothing you can do about it. They're independent. And the media were telling him this, and the Democratic Party was telling him this, and the high levels of the Republican Party were telling him, oh, the FBI is independent. They can do all these things. They can have special prosecutors. They can do all of this to harass you personally and harass you as president to prevent you from functioning as president because you're tied up in all this other nonsense. And there's nothing you can do, even if you have personal knowledge that this is some kind of corrupt or criminal operation being run against you. Because he certainly has the personal knowledge that he didn't engage in the Russian hoax. The Russian collusion hoax was proven to be a hoax. Coming out of the Democratic National Committee or whatever, the Steele dossier, right? It was proven to be a hoax even by the Mueller investigation. So that was the first indication, certainly, at the highest level, that this whole system had broken down. That there was nobody that told Mr. Trump, wait a minute, you're the President of the United States, you have this constitutional authority, nobody can take that away from you. You know that they're running an operation against you, rogue agents are running an operation against you in the FBI, and therefore you have the constitutional right to go in there, assemble a team of honest FBI agents, and we're always told, 95% of them are, they're diligent and trustworthy and God-fearing and blah, 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 whatever they are. They would never engage in any bad behavior. All right, out of that 95%, you find enough to go in and expose what's actually going on with the rogue agents. Nobody told him that he could do that. And as a result, he sat back with his finger in his ear, in a sense, right, while he was being pummeled by these people. Now, what does that tell you about the whole system? I can understand why the Democratic Party wouldn't tell him, why a lot of the Republicans wouldn't have told him. What about the advisors he had? None of them read Article 2, Section 3 of the Constitution and drew the obvious conclusion from this. See, everyone is willing, this is the problem here, everyone is willing to accept this concept that there is a thing called the administrative state, that it is basically a fourth branch of government, which the Supreme Court actually called it. They said, this administrative, I can't remember the exact case off the top of my head, but the statement is, we have this administrative state which has deranged our three-branch theories of government. It is a fourth branch of government all to itself. And when you read that, the first thing that jumps off the page is, wait a minute, where does this three-branch theory come from? It comes from the Constitution. And if it's deranged, the three-branch theory, then isn't the administrative state necessarily unconstitutional or presumptively unconstitutional in whatever it does? Don't you always have to look at it from that perspective? And, of course, they don't. And the average American and the average lawyer certainly, and I think the average politician definitely, thinks, oh, well, these agencies, they're independent, and there's nothing we can do about that.
Yeah, and that's one more thing that you just basically led up to there, is that the Constitution provided for checks and balances between the three valid branches of government. But if there's this fourth one that's usurping unconstitutional powers against the other three, and there's no checks and balance against it, that's another aspect that you're talking about.
Well, you see, there actually was, because the example I gave you with Trump, where Trump knows that he didn't engage in these activities that he's being supposedly investigated for. He didn't engage in Russian, quote-unquote, collusion. In fact, collusion, I don't know what's the statute that talks about collusion? I don't know of any such statute. That's a word that the media was using, kind of a catch-all, invented term. But Trump, he's the president, he knows that he didn't do any of these things that are being bruited about him. And he has the duty faithfully to execute the laws. And he sees that there must be people in the FBI, Department of Justice, CIA, for whatever, intelligence agencies, who are engaged in rogue activities intended to undermine his ability to function as president. And they are, in fact, there's a statute, 18 U.S.C., Title 18 of the United States Code, Section 371. That kind of activity is considered to be defrauding the United States, preventing the United States from receiving the full and fair operation of some branch of the government. So there's at least one statute, and there are a number of others that can be applied to it. And here he is unable, even though he has this constitutional authority which can't be taken away from him, he's unable to do anything because everybody treats it as an impossibility for him to do anything. Right? There's the independence. So here we have an agency that can run amok, at the upper levels can be manipulated by rogue agents, can have all of these terrible effects for 4 years, and nothing can be done about it because it is, quote-unquote, independent. Well, how can it be, quote-unquote, independent, engaged in rogue activities? Right? Even if you said, well, we don't want the president going down there every day and looking at the particular investigatory notes that the agents have developed in various cases. Right? But that's not what was going on. What was going on was the rogue agents were engaged in a conspiracy against the presidency. The presidency, CY, not just the president himself. They were preventing the presidency of the United States from functioning properly. And supposedly, all of these gurus and experts were telling us, there's nothing can be done about that because it's an independent fourth branch of government. Yeah, it's really independent. It's so independent it can be destroying the very government of which it is independent. Well, I mean, I treat that as a paradox. But there it is. So that went on for 4 years, eventually, derailing itself when the hoax nature was exposed, of the Russian collusion scam was exposed. And yet, it's basically some of the same people in the FBI that are running this documents investigation, as Espionage Act investigation, obstruction of justice, whatever they're calling it, these various statutes that they're trying to hang the documents on, like a Christmas tree ornament. And nobody is coming out and saying, well, wait a minute, let's go back to what was going on for these 4 years. What's happened here? Okay. There's our problem. It comes back to the administrative state problem. It's not a Trump problem. It just became acute because of Trump being the man that was elected president at the time, and that they still wanted to destroy him for whatever political reasons. But it's the result of the nature of this system that has been created. And in every area. You can certainly look at it in the public health area with everything that was going on with the COVID business, the lockdowns, the masks, the vaccinations, and so forth, mandatory vaccinations, so forth and so on, where those agencies were treated as above and beyond, not not just criticism, but you couldn't even inquire. Well, you had the back and forth between Senator Rand Paul, and Dr. Fauci about gain of function research, and hadn't these American agencies assisted the Chinese Wuhan laboratory with information or money or what have you, but engaged in some kind of assistance back and forth. Okay, that went on for I don't know how many weeks when these hearings were being held. Now that's all essentially gone. Right? Well, they were independent. Nothing we can do about it. Well, that's not the constitutional system. Even if you said the administrative agency could be set up for the purpose of, say, assisting the President of the United States in fulfilling that duty he has to take care of the laws to be faithfully executed. So we created an FBI. And remember, they really didn't create an FBI. It goes way back when. Bureau of Investigation, and Hoover was the man that created the FBI we know today. That was the result of this one individual who had a very dark side to him. All right, a lot of things he did were completely illegal. But this is his creation. And the independence of that thing was largely his doing. Right? Because he was the head of the FBI for so long. He was a sacrosanct individual, if you will be, right? He was the ultimate graven image that you had to bow down in front of. So that agency sort of developed, I would say, as a result of Hoover, a hangover from the Hoover years, developed this concept of infallibility and untouchability. And people have just accepted that. And it's rather grotesque in that area because law enforcement is a very dangerous field in which to give anybody that semblance of infallibility, untouchability. Because we certainly know that they don't have incorruptibility. That's clear enough. And yet these other agencies function the same way, some more than others. The public health agencies we've seen, they function exactly the same way, maybe to even a higher level, because they claim the mantle of science. Oh, if you question Dr. Fauci, you're questioning science. He himself said that. Well, that's not the way science works. Science works on the basis of constant questioning. There's nothing in science that is above being questioned by hypothesis. And yet here was this man saying, well, you can't question me. I'm kind of the statue in the temple of science. And you can't question any of my pronouncements, or the pronouncements coming out of, the Delphic Oracle of the NIH or whatever, the FDA. These have to be accepted. Well, look at that and say, well, what has that got to do? Number one, what has that got to do with science? Well, number two, what has that got to do with representative government? How could they set up these little tin gods who can look at you and say, there's no way that you can challenge what I'm doing. You can't even ask me the question. That was Merrick Garland's statement a few days ago. You can't even ask the question of whether the FBI might be, in some senses, engaged in improper activities. Can't even question that. Why not? See, so we really have a secret police operation, if you want to get kind of down and dirty about this. That's what's been developed here. Because you look at all the secret police that we talk about in 20th century history. You had the Cheka, then they became the OGPU, the NKVD, the KGB, all of those various iterations under Lenin and Stalin and then later Khrushchev, right, of the secret police in the Soviet Union. You had the secret police of Stasi in East Germany. You had the Securitate of the Ceausescu's in Romania. Right? You think of these secret police organizations. Well, they really weren't secret in the sense that nobody knew that they existed. Everybody knew that they existed and was in terror of their existence because they made decisions. They developed policies. They picked targets on the basis of secret criteria. You could never go into the NKVD and say, well, why did you arrest my brother-in-law? They weren't going to tell you that. And in fact, if you asked that question, you'd be the next one to go to Gulag. And that was true of all of them. The Stasi in Germany, when that finally collapsed, and people got to look at those records, and they saw the extent of the informer network that had been created. Informers in one's own family, informers living across the street, informers in one's own business. All this was unknown. The existence of that level of spying, and of course what the spies were providing to this, to the security agents. A lot of it just innuendo, personal grudges or whatever. So that's the kind of thing you have here. There's no, I guess the word is transparency. Maybe you don't want it to be transparent because they are engaging in legitimate law enforcement functions. But you want someone to be able to conduct inquiries when a question of impropriety arises. And in this particular case, I say this is the peculiarity of it. The impropriety in that particular agency would have been directly subject, constitutionally speaking, to inquiry by the President of the United States because he has the authority to take care of the laws to be faithfully executed. This agency was given to him by Congress to assist him in doing that. And now it's not doing that. At least the rogue agents aren't doing that. So it would be his authority, constitutional authority, to conduct some kind of investigation. But everybody told him, oh, you can't do a darn thing. They're independent. You see the problem we've gotten into? I mean, even Stalin didn't treat his secret police, NKVD, as being independent. He would change the head of them. Right? He took out Yagoda and he put in Yezhov, and then he took out Yezhov and he put in Beria. Right? He was in complete control of those things at the top level. But here in the United States, our secret police are even more independent than Stalin's secret police were. It's incredible. And Stalin was operating on the basis of what? Well, the Stalin Constitution, which was a joke, it was never enforced. Right? It was just his personal power. He really didn't have any clear-cut constitutional authority because he didn't pay any attention to constitutional authority. Here we have a constitution which everybody says, supposedly, is in control of all of the government. Everything is subject to the Constitution, right? As Merrick Garland would say, the rule of law. What law, Merrick? What law is the highest law? Tell me. There's a quiz, right? What you win what's behind door number 3 if you give me the right answer. What is it? It's the Constitution of the United States. Who was the highest law enforcement officer under the Constitution of the United States, Merrick? That's behind door number 2. That's the Jeep Wrangler that you're going to win. What's the answer? It's the President of the United States. It says so. Then why is this going on? And then he doesn't win the prize behind door number 1 because he doesn't have an answer for that question. None of them have an answer to that question. But that's the question that has to be asked. And we get right back to the whole administrative state concept. The idea from the beginning was to have these agencies made up of appointed bureaucrats who were going to be loyal to what? To the agency, number 1, and then number 2, to some power outside of Congress and ultimately outside of the people who elected the members of Congress. Once these agencies came into operation, they were the experts. They knew what needed to do. Congress step aside, just give them the authority, generalized authority, give them the money every year for the appropriations, and everything will be fine because they are the infallible experts, whether it's law enforcement, whether it's public health, whether it's securities markets, whether it's the Department of Education, for which you can find absolutely no justification in the Constitution. There's not even rationalization. It's impossible. Department of Energy, run down these lists, all right? I suppose the Department of Commerce is probably the only one that you can actually find a constitutional statement. Congress has the power to regulate commerce among the several states and with foreign nations and independent Indian tribes, right? So they say, oh, well, okay. There's a specific congressional power, and it's using this Department of Commerce to help the president in performing the functions of that Congress has given in terms of regulating commerce. Okay, fine, one. State Department, probably another one. The president has the power to appoint ambassadors to deal with foreign governments. So, okay, we're going to give him a State Department that will help him do that because he may not be competent enough in foreign languages, in foreign culture, in the way foreign governments run, whatever, blah, blah, blah. So we're going to give him some experts. But ultimately, who's in charge? The President of the United States is the one who actually makes the treaty. He could sit down with Putin today and make a treaty. Now, he'd present it to the Senate, and the Senate would have to advise and consent or refuse to advise and consent. But who's the man in charge of deciding that? So if you look at go back to the Trump era, when they were saying, well, Trump is too close to Putin. Well, maybe Trump was trying to defuse a situation, an international situation, which would drive Russia in the direction of alliance with China, which we certainly don't want, something that they didn't want for a very long time. Right? We wanted to detach China from Russia, or Russia from China, whichever way. Right? And who is the final say? Who's the final arbiter in that? It's the president. Right? He sits down with the other side, drafts a treaty. Well, the Senate can, advise and consent, approve or not. But there's no way you can tell the president, well, you can't go and talk to Putin. Right? That's it. You have this constitutional authority. What's the check and balance? Well, if he even started to talk to Putin, the mass media and the Democratic Party would have been advocating, oh, this is treasonous. You're talking to our enemy. Oh, really? Wouldn't it have been smarter for Roosevelt, for instance, after the Battle of Saipan, when the Japanese realized they were going to lose the war and the Tojo government fell, he had to be replaced, that somebody would have advised Roosevelt, the smart thing to do is let's end this war now. Let's negotiate an end to this war because we've got an even bigger problem with the Soviet Union, with Stalin. Let's get the Japanese off the table. The Japanese, get that out of the way. Oh no, couldn't do that. Right? But Roosevelt had that authority, and I think if he had done it, no one would have questioned it. But now what's happened with Trump being the fall guy here? We have this argument that, well, he can't even make any approaches. Trump couldn't make any approaches. Now, they're not using that with Biden, of course, because the Democrats are in power, and so they're not following the same rules that they applied to Trump. But that's one of the clubs in the bag now. Oh, it's the foreign policy experts, the CIA. The intelligence agencies are the ones that really should be making the decisions here because they're the experts. They have all this secret knowledge. Right? And the president should defer to them. Oh, okay. So now foreign policy is going to be made by an even more shadowy group than the people who are making public health decisions. And then you have to go back to the fact that 15 heads or former heads of the intelligence agencies said that the Hunter Biden laptop was Russian disinformation. Okay, this is the level of competence of these agencies, or they have been so politically compromised. Which is it? Take whichever one you want.
Miles Franklin Precious Metals is one of America's oldest and most trusted bullion dealers. Miles Franklin is A+ rated and accredited by the Better Business Bureau, licensed and bonded, and has 0 complaints ever registered. Here at Liberty and Finance, we are licensed brokers with Miles Franklin. To order, simply call us, discuss your needs, and we will let you know our live inventory, prices, and availability, and lock in your order over the phone. Once your order is locked, the price is held for you regardless of market fluctuations, and the metals are reserved for you awaiting your settled payment. Within 1 business day of ordering, you will receive an email invoice detailing the order and payment instructions. Miles Franklin accepts payments by bank wire, ACH or electronic check, money order, check mailed priority mail, and cryptocurrency. The fastest forms of payment are bank wire and cryptocurrency. Upon settled payment, metals will ship out within 3 to 5 business days. You will receive tracking information via email. Domestic shipping charges are $15 for any order under 500 ounces of silver or 10 ounces of gold. For orders larger than that, domestic shipping is free. The package will be double boxed, fully insured, and labeled discreetly, with no indication of the contents inside. For your privacy, the name Miles Franklin will not even be on the package. To talk to myself, Elijah, my brother Kaiser, or my father Dunnigan, call 1-888-81-LIBERTY. That's 1-888-815-4237.